participants, ladies and gentlemen, to this session. Though it is convened on a second Saturday, I'm happy that quite a few professionals have shown interest to join this discussion forum. I would like to call this as a discussion session because all the members here who have logged in definitely have a host of experiences, a lot of unique situations they would have faced in their career in IBC in this profession. With that context, with that backdrop, it will be my endeavor to present to you a kind of scenarios, situations, and probably where all a company secretary can add value to this insolvency profession, and how he can discharge his role more effectively, more efficiently, and in a manner befitting the expectations of this profession. This profession is a very nascent profession. I'm talking about insolvency profession. And comparing to the ICSI role in developing the company secretary profession, insolvency is still, I should say, a kind of a beginner, and of course, it has faced its own trials, tribulations, and challenges in the process. A lot of amendments, a lot of complete changes, U-turns have taken place in the IBC law and regulations, concerning IBC matters. A lot of situations have given kind of impetus to such changes. I can quote the recent case of Kalyani Transco, which is popularly known as the JSW case, or the Bhushan Power and Steel case, where the whole system has been completely rattled by the Supreme Court decision. So that sets me in this context. And when ICSI IAP asked me, Anjali was talking to me. So amongst a few topics offered to me for this session on a Saturday evening, Saturday afternoon, I jumped on this role of CS, the profession, and how he can add value to the insolvency profession as well. So, ladies and gentlemen who have logged in here, once again, I welcome you to this session. I promise you that we will not take you to the road of boredom. We will take a kind of a boardroom situation where it will be like a collective discussions and kind of suggestions from your side will also add value to these discussions and our professional journey. I have the benefit of my team, which has helped me immensely in preparing a few slides and also guiding me in what are all the things which I can share with this professional colleagues in this forum. Nevertheless, I promptly would like to put a kind of a disclaimer that there are people, there are professionals, there are insolvency professionals who have done more kind of work, complicated work, complex situations they would have faced in their career, and probably they have not shared, they have not come to the limelight, or they are unsung heroes as of now. I would like to request such kind of situations which you have faced in your journey. In every IBC matter, it's a turbulent kind of a situation. Companies come under IBC in different contexts. Sometimes companies come like an orphan. The directors are not there, assets are not there, nothing is there in the company, but still somebody pulls it into IBC, and some insolvency professional, has the burden of finding its fathers. There are situations where companies have their assets, but they are all languishing, open to natural elements, unscrupulous elements, kind of situations. Companies come with assets, but not so good management, financial impropriety things might have happened. So that kind of situations also come. Companies also come like a case of Go Air, where the flight was operating, systems were okay, but then impending financial default forced them to come into IBC under Section 10, a kind of a voluntary initiation. So that is the kind of backdrop I would like to share with this participants here. Please do feel free to check me, to stop me at any point in time, and share your thoughts. And may I also have the kind of privilege to sometimes tap the doors of some of the participants here, whom I'm able to see persons like Mr. Bhavesh Rathod, Vishnu Tulsian, Gaurav Mittal, Hemant Kumar Singh. Some known names are also there. And from my team, Mr. Nageshwaran is a very senior insolvency professional, not only in Indian context, he is also a qualified insolvency professional in US, UK territories. Piyush Gupta, Prem Narayan Tripathi, Ramakrishna Gupta, and Rajiv Malik, Ms. Ramela Rangaswamy, Sudhanshu Gupta, Vivek Sharma, and Mr. Shailesh Baheti. These are all the names which I could currently see in my screen. As we go on, probably thinking some more professional colleagues might join. So let me try to share a small kind of a PPT which we have made that may give some kind of a roadmap or an idea as to what we are trying to explore as the company secretary role. Maybe I just thought that another minute of your time. ICSI IIP has organized this program. Naturally, we belong to this prestigious ICSI profession. There are equally other professionals also available in this space, in this IBC space. CAs, companies, cost and management accountants, CMAs, advocates, general banking professionals. So they are also in this space, and they are also equally good. But what makes the company secretaries, having an edge over the other professionals? Is it because we love our profession, we value our profession, so we think that we are one notch up in this professional, I should not say a battle, but in a healthy competition? Is the company secretary running ahead? Is he putting his nose on the line ahead of others quickly following him? If somebody asks me that question, being a cost accountant also myself, and having interacted with a lot of chartered accountants also, I frankly and honestly feel that company secretaries definitely have an advantage, an edge over other professionals, in the sense that we have a lot of plus points, advantages of working very closely with the management, with the directors of the company, other stakeholders of the company, be it part of a board system, compliance system, or reporting to various authorities, what happens in a company. So that way, it puts CS in a spot of limelight, I should say. At the same time, company secretaries are also having a lot of responsibilities. So they render their professional discharge of a role, but always they also have a lot of responsibilities, code of conduct, and wherever there is a conflict, they are supposed to act in an unbiased manner. Added to this, we have our own insolvency profession. Every day, we happen to see a lot of disciplinary proceedings. Our team, Mr. Raghu, is there in from our team. So he also, highlights to me, puts to me across, every time there is a disciplinary proceedings by the IBBI. So my eyes first go whether he is from CS or from CA or from CMA, the kind of, the first initial reaction to such kind of things. If it is a CS, then I go into the details, find out what kind of remarks have been made against his professional duties or how he has performed his role. So that way, we are concerned more about our own profession, that there should not be a blemish, there should not be any black spot. More so, this insolvency profession deals with a lot of situations where things can go wrong. Things can, put you in kind of a difficult situation. A small slide, a small slip somewhere, and the die is cast against you, and things can go wrong. As per Murphy's law, if they can go wrong, things will go wrong, and they will go wrong at the most inappropriate time for us. So we have to guard against all kinds of situations. So let me not take you more into this initial context setting. Let me try to upload my brief presentation. Anjali, I can add my screen to this and present it, right? Let me try. Is my screen is visible to the participants? Akila, can you see my screen?
Yes, sir.
Okay. This is a kind of a roadmap. So, company secretary, whom we are, and we have already seen, and why is the role of CS critical under IBC? Different roles of company secretaries under the IBC process. So, our team has been able to identify 5 areas. So, what are all those 5 areas we'll be able to see quickly in this discussion process. 5 areas we have broadly classified. As an insolvency professional, what kind of roles we are playing, like, IRP or RP or liquidator or bankruptcy trustee, authorized representative kind of a thing. The second situation could be like a KMP of a company, the company which is not under IBC, but it's trying to find where all they can, take advantage or utilize the provisions under IBC. The third situation is a company secretary is a KMP of a company which is undergoing an IBC process. So he will be in a kind of a difficult situation, but what is expected of him in that situation? The fourth one is as a consultant, where as a freelancer, what kind of a support services he can render to different stakeholders. And the last one, this is also happening in some situations in a company where secretarial audit obligations are there, but the company itself is under IBC. And a few practical insights as we go along in each of these processes. I thought I should take care of, sharing some inputs which could be of use to the participants. And then there is a question and answer session for about 15-20 minutes. My idea is to complete the discussions, complete the presentation in about 1 hour 40 minutes, 1 hour 30 minutes kind of a thing. And thereafter, we can spend some time on, a freewheeling discussions, sharing of ideas, and conclude it at the earliest on a second Saturday. So let me go to this kind of, the role of CS is critical under IBC. We all know that what kind of expectations are there. Compliance management is a key responsibility, and also, kind of advisory, regulatory interface, record keeping, corporate governance. These are, a general kind of role of company secretaries in their professional discharge of, their duties and responsibilities. Let me speak about a small diagram which we have charted out. So here we are able to capture these 5 situations as an IP, supporting, the processes, leading the process, I would say, not supporting. You are the, person in the front. So the first bullet goes to your head. So that is the process which you are leading, IRP or RP, a liquidator. You can be a liquidator in a company where, a normal circumstances under Section 33, which is inability to pay the debts. The company goes through, say, ARP, fails, and then comes into the liquidation net. On the other hand, you can also be a liquidator in a voluntary liquidation case, in a situation of voluntary liquidation. So the discharge of duties in voluntary liquidation is quite different from a normal liquidation case. Maybe as we go along, we will look at those aspects. And bankruptcy trustee in a PG to CD case currently, authorized representative is for the class of creditors. And I can also tell you that Regulation 30B of CARP regulations talk about an audit during CARP period, which can be discharged, that audit function, by an insolvency professional with the requisite qualification. So as an IP, you can do all these kinds of role you can play. As a consultant, you have the possibilities of advising, supporting the IRPs, RPs, liquidators. Here, I could say that some of the situations, every IP will appreciate that, as a single person, you cannot handle an IBC process. You need a system, ecosystem of people supporting you. So where all you can manage with your own team, that's nice, that's well and good. But in case you need some kind of an external support, a reliable kind of assistance, that makes you your process more peaceful, and a kind of relief you will get. End of the day, you can go for a good sleep, a peaceful sleep. The opportunities as a consultant also goes to a potential prospective resolution applicants, and drafting resolution plans for them, or kind of participating in auctions in liquidation, advising them as to which assets you can pick and choose, or what kind of conditions, what kind of a drafting is required, reliefs, concessions, those things, as a consultant, you can do that. Also, an aggrieved promoter, if he is there, if you are advising him, there you have possibilities of, coming out of this IBC net. So that is a Section 12A proposal you can draft, or even sometimes OTS also may work out in some cases. So these are all the possibilities of as a CS, as a consultant, what are all the works you can do. The third kind of situation is like a KMP of a company, but the company is good, solvent, I can say for the moment, and it has certain assets, certain receivables, claims, and you are not able to recover them. Take the case of a BCCI going against Byju's. So you are going against another corporate debtor, either under Section 7 or 9. That kind of a process you can initiate against the people who have liabilities towards your company. The next situation I have listed is assisting the company in filing Section 10 application for the CD itself. So this is the reason why I said you are a KMP of a company. You are not solvent right now, and you face some kind of a problem. So that kind of a situation, how are you going to approach the authorities? I can put the case of a Goi Air, which went into insolvency proceedings under Section 10 of IBC. So that could be a situation, and you might be a company secretary there. So at that time, what are all the roles which you can play? You can advise the management. That is an important role. And you are a solvent company, and you find that today you are solvent, but you would like to call it quits, by way of going for a voluntary liquidation, because you see things today they are good, but tomorrow what is in store for you, we don't know. So that is a situation where filing a voluntary liquidation. So there again, you are the company secretary on that company, and the management says that, let's say goodbye to the business. So far so good. You have not defaulted to anybody, and you would not like the situation to be there, and you would like to sign off peacefully, settling every debt available, every claim against the company. You have the asset, and you would like to pay off everybody, including the shareholders. So that's a voluntary liquidation under Section 59. And the last but one, KMP of company under IBC. You are a KMP, you are a company secretary in that company, which is going through the IBC process. What is the role you would like to be playing in this situation? It's a difficult situation. You are in a corner, you are in a tight spot. You can only say that, whatever you may like to decide whether you like to continue in this company or go elsewhere in your own interest. But then, depending upon the situation, what you would like to perform. And in that kind of situation, you may assist your promoters, your directors to submit a proposal of 12A for settlement under OTS kind of a thing. That's possible. And the last scenario is the secretarial auditor of a company under IBC. So this is the kind of a quick roundup which we will be discussing. And in the process, we're all, we would like to add some real life situations I would like to share. And if there is any point or comment or any interesting episode you would like to share, please do stop me. May I ask our team members, sir, are you able to hear me? The audio is okay?
Yes, sir, we are able to, Nageshwaran here, we are able to hear you clearly.
Oh, very good, sir. Very good. And the screen also is visible, right, sir?
Yes.
Okay, very good. Thank you, sir. Thank you. So I'm just touching upon this first scenario where the CS as an insolvency professional. So all of us here would definitely appreciate that, we have a very good kind of a grip on a corporate life cycle. When the company came into existence, what kind of board of directors are there, governance, compliance situation, master data, you will have on a quick glance, you will be able to say whether this company is a good corporate citizen or a laggard or a perennial kind of a defaulter. You will be able to assess in a few minutes. So that's the kind of an expertise we have. So that helps you in kind of unraveling the insolvency proceedings under IBC. You can lead the CARP process, and in case it doesn't go well, you go to the liquidation process. Sometimes you also get appointed as voluntary liquidator, and you have to coordinate with every Tom, Dick, and Harry in your IBC process. It could be like, the promoters, the creditors, the employees, the regulators, and sometimes, suddenly you will bump on a kind of, district administration like a collector or a police office. In one of our case, we are seeing a situation of kind of engaging with Taskmark, where, the people there, after utilizing the products sold by Taskmark, they are misusing the properties belonging to the corporate debtor. So that's the kind of situation sometimes we do feel. Ensure all compliances. And one line which, I thought I should add here, as an insolvency professional, the kind of importance we must give is on integrity, accuracy, and the timeliness, following the timelines as per the code and the regulations. And you will all agree with me that the insolvency profession is not for those people, who would like to macro manage or just have a top surface view and then leave everything to somebody else in the process. Definitely no. It calls upon, a contribution from everybody, no doubt. But at the same time, you are checking and you are having a tab on all these items, where all things can go wrong. I think that's very important. And integrity, is highlighted everywhere in all our code of conduct, not only in CS, also in insolvency professional code of conduct as well, governance, corporate governance as well. So that's a very, very important hallmark for a good insolvency professional. We see now and then, not in this part of the country, but elsewhere, we find a lot of situations where complaints are made about the integrity and kind of, financial dealings, transactions, conflict of interest matters. So there, I think definitely things can go wrong. And it's always better for you to take 2 minutes more and see whether this particular decision of you is worth taking it now. Getting into a situation, getting into a transaction, whether it is against any principles. So that is a very, very important element I thought I should share with my colleagues here. So roles, we all know what kinds of roles, we have already talked about it. Core responsibilities. The core responsibilities, sometimes comes with a surprise package to you, kind of, asset management. What kind of business the company has been doing it. Suddenly you become the CEO of the company, and the people knock your doors. So you have to take some decisions at that point in time. And such decisions can be, it could be relating to financial decisions in the business. Example, you may have to quote for a project. We are handling a situation, a company where it's an EPC company, which has come recently to a conclusion. So we have to quote for a project, an EPC project, which involves high capacity cranes, supporting equipments, trailers, weights, tools, tackles, and you have to work against the nature. The kind of erection work with huge cranes, lifting equipments, and all those equipments have to be certified for safety. Labor is involved, and costing is involved. More so on compliance aspects, on the costing aspect as well. So how much you should quote? Are we quoting the right price? This situation you come across when you are in the business of the company, where the company is continuing its business. Okay, so coordination with committee of creditors, and then thereafter you go through the resolution plan process. If everything goes well, good. Even then, you don't, probably in a position to assume now, after 4 years of your resolution plan successfully, and everybody clapping, still after 4 years, things are even being drawn into some kind of disputes, questions, and being set aside. That makes situations quite difficult. So auction process under liquidation is also another responsibility, where you face innumerable challenges. I think I have put some kind of thing on this, what kind of challenges. Yeah, we have a separate slide on challenges. What are all the challenges we face? I would like to take you through those challenges. Some of you might like to add to those challenges as well. Represent before NCLT, NCLAT, and other forums, including, all forums like civil court, labor tribunals, industrial dispute cases, EPFO cases, all places, the insolvency professional is required to kind of present their case. And procedural compliances with other statutory authorities during the process. Wherever you are there in charge of a company, if you are in charge of a company doing some mining works, what happens to the mining lease, transactions, obligations, renewals? Every other authority is just waiting. All along, it would have been, matter of the company and the directors would have been just going around the process without any kind of a thing. But when you sit on the chair, when you become the RP and when you become the liquidator, suddenly, the people sit up, wake up, and then, start firing their arrows as if, it's the last day for them to recover something from the company. That kind of a situation happens under IBC. So that is the professional roles and, core responsibilities. Let me go to the challenges page. I think this is a very important slide and important page where I have tried to put across situations where more challenges can happen in each of the matters we are handling, and each one is unique. There is no kind of a template that this kind of a situation will come. Timelines, IBC provisions, complying with them, regulatory requirements. A Form H has not been filed, which has been made, very kind of a loud remarks and strictures in the JSW case. So how that kind of a slip can happen, we don't know. We don't know actually, what is the situation there. JSW case is not a small, ordinary one. It is a very large kind of a situation. Professionals and IPEs and support services, whatnot. So many kind of professionals would have been definitely involved with huge kind of fees. So the Supreme Court remark on this case about certain irregularities or omissions on the part of the insolvency professional definitely makes a case that how much more vigilant the IP has to be. Conflict management amidst SRA, COC, and promoters. I wanted to actually kind of give a small idea in this particular line, conflict management amidst SRA, COC, and promoters. So it's a three-dimensional kind of pull happening in particular case where a resolution plan has already been approved by the COC, but the promoters have challenged it, and it was for a long time before the appellate authority or the Supreme Court. So there is an SRA whose plan has been approved by the COC, but it's awaiting the approval of the adjudicating authority. Now the promoters are challenging it, and a lot of time lapse has happened in between. The COC is the other party who is now kind of in a disadvantageous situation. They feel that the plan which they approved, it was about, let's say, 4 years ago, does not make any sense for them to continue with that plan. So the COC is now looking at why not we go for a kind of a quick repeat of the process. Why not we go for a re-CARP? So here the SRA is saying that I am patiently waiting, putting my money into the system, believing that IBC will give me the asset after I have gone through the entire system in a very, very meticulous manner. That is the claim of SRA. COC says that, yes, all good, very good, but 4 years have gone. Today, the valuations are different. If I give you the company today, it's like giving a golden apple in a silver platter. Why should I do that? I waited patiently. I have not got any money. Okay, the promoters, on the other hand, they say that I am challenging it. I would like to offer X price, and that price, the bankers should take that price. Something like that. This is a kind of a management, conflict management. May I request Mr. Nageshwaran, sir, in this kind of a situation, SRA, COC, and promoters, maybe I think you can share in a few minutes what could be the role of the IP, the RP, as well as the adjudicating authority. And if there is any other participant willing to share, this is a triangular kind of a situation, a challenge. Nageshwaran, sir?
Yeah. See, peculiarly, the position of insolvency professional as a RP becomes a very peculiar thing, that if at all, if they talk on any one side or take up anybody's thing, any of the stakeholders matters,
Yeah.
the core, immediately the question will be shot, what is your interest?
Correct.
So that really becomes a little tricky situation. So even where technically we are supposed to be advising the court and handhold them and advise the court or give them a guidance in related matters of IBC, many a time, because of this particular clash of interest, what is your interest, that type of it is raised, it becomes a situation where we cannot really answer, and the other people, the stakeholders, will take a cue that you are siding with the other person. So most of the time we need to, even though we know that there is a different line of action need to be taken, we will have to wait for the court to come around with that. And in fact, if at all, if they ask for a question directly put to us, then only we can give them that advice. Otherwise, we need to keep quiet.
Absolutely, sir. Absolutely. So I think this kind of situations would have come in quite a few other cases as well. I don't know. But here is a situation where the company, after coming into IBC, doing well, and maybe because the financial servicing obligations are not there, and they have a huge cash pile. I've seen some cases it is there, company doing well, and surplus cash is there in the company, but unfortunately the creditors are not able to lay their hands on it. So maybe I think some kind of quicker decision by the adjudicating authority in taking all aspects together is the only remedy, I think. Am I right, sir?
That is true. Actually, even though we know that the money is available there and need to be given across, except in one or two cases where NCLT themselves, particularly for example, in the case of IL and FS, in
Yeah.
one particular case, they have allowed the money, whatever was available in the corporate data, to be given across to the financial creditors who
Correct.
had submitted their claim. But otherwise, it becomes really a situation where the money cannot be really moved, put across for any payment towards the claims which have been submitted already. And
Yeah.
if at all, if it is, even if you apply to NCLT for seeking such a permission, the other stakeholders may take it differently, and they will say that it should not be done. So it becomes a war. Then it becomes really a situation where unless otherwise NCLT themselves take a decision, we are not in a position to go for the distribution.
Correct. Correct. Absolutely. Any view from participants in this kind of a conflict situation? I invite ladies and gentlemen, here is an opportunity to share your views. Definitely, whatever it is, absolutely no problem. Your view is your view. Kumudini, ma'am, are you there? You are from the southern part of the country. Okay. Well, let me run through the remaining portions, and if there is any other questions, we will come to that. Determination.
Sir, I want to share my view on this.
Yeah.
I am also basically a company secretary, and I'm also acting as RP in cases. But I have chosen to play quite active role in running the process.
Okay.
Although I have started practice only in 2020 only. But in my process, I am taking the lead to enable all stakeholders to take the rightful decision. For example, in such a case where the COC is trying to take a view which is not as per the spirit and the law of the IBC, then I have to take a strong stand that this will only derail the process.
Absolutely.
So in my case, I have been there are instances in my CRP process also where I took a very strong case and even convinced COC members that if they take any decision, otherwise it will only hamper the process. And it will not be in the interest of all stakeholders, because if litigation goes on, then we as a professional will continue to have the fees, but it will be damaging our image also, because everybody will know that this was the RP who is involved in this case. And because of his, maybe not because of him, but he is also responsible to some extent in derailing the process.
Correct, sir. Correct.
So in my case, sir, I have been taking very strong lead in as far as COC members are concerned. So wonderful. Whenever there is some kind of essence, especially the example which you have quoted, had I been in this situation, I would have advised the COC not to take such kind of decision to now, because IBC doesn't permit.
Absolutely, sir. Absolutely.
To rethink. Yeah. Once you have approved. Even in many cases, bankers seek advice in other cases.
Yeah.
So I advise them appropriately. Now the position is that I command adequate respect from COC members, because bankers, they keep on changing. They are COC members, but every 2-3 months or 6 months, sometime new person will come who may be from some other branch. He is not aware of our IBC. Even as latest at yesterday, I want to share my experience with the participant
Yes,
that
sir.
I before COC, I have a practice of visiting each COC member and apprise them of the background of the agenda so that there is effective discussion in the COC meeting.
Wonderful.
Normally, these people don't come prepared. So what I
Correct.
have prepared, I have made a practice that before, after circulating or before circulating agenda, I decide that I want to get through some decision by the COC. I ensure that I visit each COC member, give them explanation, understand their queries, and then ensure that they vote and they are able to participate effectively. And today, yesterday I went to one banker. He is one of the leading banker, and they said something because that person was transferred from vigilance section of that bank, and there was a question that I told him that I have to take this call as per section 20. I have a responsibility to keep the corporate debtor as a going concern. Correct. So.
Yes.
Although I have a right to take all decision, but I am bringing this matter before the COC to ensure that there is adequate transparency in the matter. And ultimately, COC's wisdom is upheld everywhere in the IBC domain. So maybe if I am doing something wrong, I may be warned by the COC member, okay, this is not correct or something like that. So that is why I am bringing that decision. And it is very important that to ensure that I am running the business, I am keeping the corporate debtor as a going concern, this decision must be taken. So, no, sir, that banker, first thing he told me, no, we don't want to run the company. Why you are running the company? This was the answer from him.
Okay.
And even the junior officer, they were shocked. Junior officer to that particular banker, they were also shocked on seeing such kind of reaction.
Oh.
So we face some kind of problem, but in the meeting, I prevailed upon them that it is my responsibility, and that COC member took a very cautious stand and asking me to kindly record my observation that I am not with this decision. I recorded that.
Okay.
And since majority were in favor of that decision, and I am going ahead with that kind of decision.
Brijesh,
So,
sir, you are from which part of the country?
I am from Delhi, sir.
Delhi, very good. You are sitting in Rajdhani, so that's
Yes,
wonderful
sir.
of you. The COC members are also in and around you, but
Yes, sir.
in a situation where they are spread across the country,
Yes, sir.
even then there is a way of as you said, your approach itself wins. On the first instance itself, because you are going there, explaining the agenda, the context, the backdrop. That's very nice of you, and thank you very much, sir, for
Yes, sir.
sharing your insight.
Thank you.
Other
Sir.
other members present also kindly. I really appreciate. I think you can unmute your video also and share, I think, your views, like what Mr. Brijesh did now. Thank you so much, sir. Thank you so much. So
Thank you, sir.
Yes, sir. Let me go to this determination of claims and security interest. We had very interesting kind of situations where suddenly a creditor comes and say that I am a secured creditor. And it's a very tricky situation in many cases, whether they are really a secured creditor or unsecured creditor. What happens when the lenders come, many times, they say that I'm having a collateral security. I'm having the assets of a guarantor. I'm having the assets of a corporate guarantor. So I'm a secured creditor. So it's difficult sometimes to convince them that your security interest from the company, from the corporate debtor, that only decides whether you are a secured creditor or unsecured creditor. So in different situations, different kinds of decisions are to be taken depending upon the case. But we have seen this particular problem coming up not only in resolution plan situations of payment being allocated to a secured creditor. Sometimes secured creditors are favored over the unsecured creditors. Similarly, in the liquidation also, Section 53 waterfall, creditors with first charge on the assets and creditors with second charge on the assets, unless they stand out, exercise section 52, not relinquishing their security interest. If they don't retain the assets, then it comes into a pool. Then it becomes a mixed one. So the first charge, second charge, and all disappear suddenly. So this is one important challenges before the IPs. Exposure to legal risk, personal accountability under IBC, it is always there, unless you are taking a proper kind of a precautions. It's a literally a very tightrope walking, and you will be skating on very thin ice, and you will suddenly find yourself in some kind of a difficult situations. Need for multidisciplinary knowledge, law, finance, valuation, strategy, operations, and marketing. Definitely this helps in having a good grasp on the thing. But when I have listed it in challenges, so the idea is to find a proper guidance, proper kind of a person who can do that. So one interesting kind of a thing, we have done in one of our case is that, every IP faces unique situation. An IP is not, all talent rolled into one. He has got certain specialization, but suddenly he cannot be a steel expert. He cannot be a healthcare expert on next day. He cannot handle, a manufacturing company of a pharma sector. So many things come into play. But the challenge is taking the right kind of help. I think challenges will be that whether you will be having the support of the COC to pay for such kind of professionals, or how do you handle a situation. I had one case like this. Just 2 minutes, I thought I can dwell upon this particular aspect. Vasan Eye Care was one company which we were handling. I am sharing the name because the process is over almost about 2 years ago, and the company is doing well now. So we had to check in about 100 of their centers, the clinics, and find out what's happening. So from my team, we had a lot of people who were engaged for this purpose. We had to train them, and we had to take some help. And in fact, Mr. Nageshwaran from our team had some very good hands-on experience in healthcare sector, in hospitals with multiple centers. So we were able to manage that kind of situation. I have my team member on this. Ilamati, are you there? Available? Just an audio input.
Good afternoon, sir. Yes, I am available.
Okay, so at the initial stages of finding out what the corporate debtor is doing and what kind of systems they have, how the money comes, cash collected, she was part of our team. Even though she's also a company secretary qualified, and she's also a leading legal professional, advising our team on various matters and appearing for me. So she was part of the team for a kind of initial due diligence. She had a lot of experience on that. Can you take a minute to explain how this process went on during peak COVID time, Ilamati?
Yes, sir, sure. So since your appointment was almost after 2 years of commencement of CARP, our initial focus was on understanding the business of the corporate debtor, to understand the modus operandi on how they are handling the operations, because it is spread across 4 states, and they had almost 96 running branches with a lot of plants where patients inflow was constant. So the main focus was on to take over the business and to run it in a viable manner, which will give benefit to the corporate debtor as well as the SRA, because we had planned to invite for resolution plans. Earlier, the company had received a plan, but it didn't go through.
Yeah.
Fortunately, post a lot of work in detail, when we understood the corporate debtor by visiting all the branches, almost team members were split into teams based on the states and centers, and all the centers was visited by the team. And the process was explained to the staff members, because the main asset of the corporate debtor was the people. We wanted the doctors to be retained and the staff. So one of the major role was in running the operations.
Yeah.
Though there were a lot of legal challenges, I think understanding and running the operations was the major role in that. And we successfully prepared the IM with a lot of details and inputs, which enabled us to receive a lot of resolution plan on competitive amounts. And finally, the corporate debtor was resolved, and
Yes.
it was revived. And it is, I think we are happy to share that it is running successfully by the SRA.
Absolutely. Absolutely. Thank you, Lamati, on that. It was
Thank
a
you, sir.
unique experience for us. You will be really surprised to note that that particular company was paying salary to the employees in 5 installments, irregular installments. On the first week of the month, they will get 1/5 or even 1/6 of the salary. And thereafter, at the distance of about 4 days apart, 5 days apart, 1 week apart, 10,000, 12,000, 5,000, like that. The salary itself was split depending upon the cash flows being received. And leave alone employees, the vendors were not paid. One bill of 10,000 will be paid on 3 occasions. So that was the kind of a situation it was running. So we had to do a lot of work in stabilizing the systems and bring it into control. You'll not know the same bill is again coming for payment, because you are making 3 times part payment for a single bill. So that was the challenge. Security interest determination, I think we spoke about it, whether secured or unsecured. Handling PMLA, ED, Benami attachments during CRP and liquidation. I think this particular area is a very, very big challenge these days, particularly after this 3rd May order or 2nd May order of the Supreme Court, whether NCLT and NCLAT have jurisdiction to take a call on attachments made by authorities in the public law domain. People say it's a public law domain, but then there are different views on this. And we don't know how the clarity will emerge from Supreme Court. I believe the Supreme Court has agreed to constitute a bench to hear a review on this, Ilamati, on this case.
Yes, sir. The recent news is that the Chief Justice has proposed to constitute a separate bench.
Okay. Hopefully, I think some solution should come. Otherwise, it is like another rainbow case, or like a Vidarbha power company, where a kind of completely different decisions have come from the apex court, much against the objectives of IBC. So this is one aspect I thought I should highlight. Real estate cases throw very complex kind of issues. So each professional here, insolvency professional, having handled multiple cases, one real estate case probably, I think, it can split your hairs and can throw you into kind of difficult situations, because the sector is such that, and the stakeholders in the real estate sector, they deal with multiple kind of challenges, situations, and money is involved, payments in cash is involved, delay is involved, corruption is involved everywhere. So that's a real kind of a challenge. And role of IRP, RP when CRP proceedings are stayed. This is a crucial challenge. I have faced myself, and many of the insolvency professionals would have definitely gone through. So you are appointed as IRP. Within a few days, within a week or 2 weeks, a stay order comes from NCLAT, and then thereafter things stay calm. You get a stay, and then you stay calm, completely no action, no activity. But what is the role of the IRP during that time? I faced a contempt. The promoters went to the court and said that this gentleman is doing something against your order, so restrain him, put him in place. Don't ask him to do anything. So let him just check himself, and he has got no role. So when an order comes from NCLAT that I have nothing to do, but what happens to the process? The company is given back to the promoters, and they run the business I am an IRP appointed, but I don't have anything to do. But moratorium is there. So the company says IRP is there, moratorium is there. I'm doing my business. Nobody come closer to me. So this kind of situations still continue. And I don't know the powers that be the NCLAT or higher forums. They have taken notice of this kind of situations. I really don't know. Maybe some of the members may have this kind of stay situations. You don't get any fees paid, right? When the stay is there. Of course, we don't do any work, so we don't deserve to get any kind of a fee. But then you should not get any brickbats, right? You don't get any bouquets, but at the same time, you shouldn't get any kind of an accusation that you are still there, but you are not doing any work there. So that kind of situation, any member present here, our friends having faced such stay situation? I can just request our team member, Mr. Raghu. Are you there, sir? Okay, no issues. So this is one issue which defies answer as of now. There is no kind of clarity whether when CARP proceedings are stayed, there should be some clear-cut kind of a thing that the company is not having any moratorium. Let the promoters do whatever they want. But if they say that the moratorium is still there, then they cannot have a free hand. There has to be some kind of a checkpoint. Otherwise, they can do their will any kind of dealings. Promoters, in an IBC company, can do anything to make most of the difficult situation. Pull out from a burning house, whatever you can. So that's the kind of situation. That brings me to the last item. Is it worth being in the firing line? So CS as insolvency professional, I have been advocating that it's a very, very important kind of a role, and there were kind of enough remuneration in the initial stages, but these days the remuneration scenario has undergone quite a big change. There has been undercutting, and there has been kind of fees challenges have been there. And apart from the fees, you also face kind of situations of being facing like a disciplinary situation or whatever thing which you have not done, but some accusations are against you. So is it worth being in this kind of a situation rather than being an IP? Can you be an assistant to the IP? Can you be a kind of a support to the IP? So that brings a new kind of situation where an IP doing some kind of a support services, wherever possible. Maybe if there is any kind of situation, if it is happening and there is a scope for it, well and good. I would rather prefer the first one as an insolvency professional to drive the process. But if it is fraught with inadequate revenue, I think Mr. Brajesh made one kind of remark. I just noted that he has been able to command a kind of adequate respect. Sir, you should get a kind of overwhelming respect for such kind of advice, because you rescue them from difficult situations. I think even in Supreme Court JSW case, the firing has been more on the COC also. We've been taking different kind of stance at different situations, and there is a collusion aspect as well. Okay, so that brings us to the next part in the CS as insolvency professional. This is one more additional opportunity. Regulation 30B of CRP regulations allow audit of corporate data if a member of the COC proposes an audit of the corporate data. They have to specify the objective, scope, estimate, time frame, and the names of the proposed auditors, and that has to be approved. A proposal under this particular regulation shall be considered as per regulation 18, and an audit shall be conducted if such proposal is approved by the committee. So the question comes here is that who can conduct that audit? The person has to be a dually qualified person, like insolvency professional is a mandatory thing, and having qualifications required for such audit. So can a company secretary do an audit of a company under IBC? We engaged recently a firm. They audited the CARP expenses. One of the committee members wanted that, so it happened. So we engaged a CA firm, which has its partners. Both the partners were insolvency professionals. So is it a mandatory thing that I should engage only a CA firm? I felt no, even a CS can render such kind of an audit service if he is an insolvency professional. I hope the members will agree with me. Like, an internal auditing under Companies Act, Section 138 of Companies Act, there is no bar on any person. They have to have certain kind of requirements to conduct the audit. They can be professionals, and all the three professions are allowed. And they can also be an employee of the company. That is a position under Section 138 of Companies Act. But here under IBC, he is an insolvency professional. Also, if he is one of the three professions, I think he can conduct an audit. This is my view. Maybe if there is any qualification counter view, please correct me. Okay, sir. This is the first link we have completed. CS as consultant to various stakeholders under IBC. We can act as strategic consultants during the insolvency process, offering specialized support to key stakeholders. What kind of role we can play is for all the stakeholders. We can start with the IP, acting as IRP, RP liquidator, PRA liquidators, and even authorized representatives. So that kind of a work we can do. Also PRAs, prospective resolution applicants, we can guide them and help them in preparing resolution plans, drafting them, and conditions, reliefs. So that kind of an advisory role we can play. And we can also do promoters requiring to bail out the company. What kind of a thing, 12A proposal, section OTS under OTS arrangement with the bankers. So those kind of things are quite possible. So we can do those kind of services to different stakeholders. So these are all situations where while drafting resolution plans, we need to go through what kind of information memorandum, the documents we get, and surprise elements are there, and reliefs, concessions. Today, I think every NCLT is happy to put that this is not in my domain, please go there, don't come to me. So any relief you have asked, none of the relief is given to you unless it is specifically given. So those kind of qualifying remarks have started occupying the resolution plan approval orders. Am I right, Mr. Raghu? Raghu is there? Consultant to promoter settlement.
Yeah, yes, sir. I'm there, sir.
So recently we have seen, Mr. Raghu, that NCLTs have started putting kind of statements where don't at all come to me nearby, and I don't have any role in this. Go to the appropriate authority. Am I right?
Yeah, yes, sir.
Yes, sir, you are right. I think all NCLTs, I'm from Hyderabad, Ramakrishna. Even Hyderabad NCLTs, all the three branches, including Amravati, denying to give any reliefs and concessions. Simply saying you go to the respective regulatory authorities.
Yes, sir, absolutely. So suddenly I find that, the charm of people coming to IBC for a clean slate.
Clean slate as becoming sir, big joke.
The scribblings in the slate remain still.
Scribblings will stay. A slate is not clean. It is used slate. There's so many scratches in it.
Yeah, absolutely. Anyway, thank you, Mr. Ramesh.
Pleasure, sir.
I find Kochi bench has issued some 3 orders, Raghu.
So specifically, as Mr. Ramakrishna said, Hyderabad bench and the Kolkata bench are very stringent in that, saying that they have a standard pattern, saying that you go to the concerned authorities. The other bench are somewhat lenient in providing the concessions.
Absolutely, sir. Absolutely. Yes, sir. So this is one kind of a challenge we have in drafting the resolution plans. Settlement plans under Section 12A, they are definitely going through some kind of challenges nowadays. Challenges are there when a Section 12A can come. So we have a classic case of Byju's where it has been challenged. So what came closer to realization of about 100 odd crores for BCCI, finally the slip between the cup and lip happened for BCCI. They could not get the money, so it is lying somewhere in a deposit now. So that is the case of settlement proposals. So that is a role as a consultant. But as a consultant, company secretaries have a larger role, I would say. There is no limitation to one particular stakeholder alone. We can do that. And apart from this, role as a company secretary, a practicing company secretary can also appear in NCLT and NCLAT representing a stakeholder. Am I right, Ilamati? As a practicing CS, they can appear before NCLT and NCLAT.
Absolutely, sir, they can.
They can. So that is again another opportunity. As a CS, we can do that. Of course, CS in employment, they cannot do that.
Right.
Yeah.
PCS can do it.
PCS can do that. Okay.
Correct.
So CS as KMP in a company where they can assist the company management taking advantage of the provisions of IBC. My screen is appearing all right.
Yes, appearing.
Okay. So company secretaries, having the role of KMP, they have a close kind of rapport with the department heads like a CFO or a CEO or the directors, the board. So where a company secretary finds that amounts receivables are lying in the balance sheet and nothing is happening, why not you take the case under IBC, push them, and then bring them for a settlement. So these things have been happening now widely, and large number of cases come to the IBC, NCLT, they get settled. So people say that it's also a very important milestone achievement under IBC, because the promoters are fearing that the company will go out of their control if they allow it to slip into IBC, where the IRP will come and take charge and hold controls. So suddenly, you find your seat, the director's seat taken by the IRPs. So filing a Section 7 or 9 application, whether it is a financial debt or an operational debt, helps the company to recover at least some part of the money. Even though people say that it is not an IBC, it's not a recovery mechanism, but still large number of cases get settled after it is filed by the creditors. And in case this company in which you are the KMP as the company secretary, you find the ship is not smooth, the sailing is not smooth, you are in turbulent waters, and you would like to go to a safe harbor, probably, a Section 10 application of a voluntary, like a Goyer case, you can suggest to the management. So that could be a kind of an insolvency resolution process, lifting your hands up. Hey, look, I am having some difficulties and I would like to get resolved. I'm seeking the help of the process, NCLT process, the IBC process. Goyer went on that way, but unfortunately, I think Goyer ended up without any resolution happening. The people did not have one more airline to survive. So they got, apart from Jet Airways, Goyer also is more or less killed. Am I right, Mr. Nageshwaran?
I just missed it. What is that?
Goyer case went on for quite some time, but then finally it could not find any buyers, and I think it is heading towards liquidation. If I am
It is heading towards liquidation because the various provisions and various cases which came in between delayed the process. Yes, and technically every stakeholder lost the
values.
To a certain extent, even they lost the value, and even, I mean, we can even say they had apprehension whether under IBC they will get the solution.
Oh, okay, okay. Absolutely, sir. Even the entire banking system is now wary of IBC, that, it's a time guzzler and money guzzler and waste of resources. So why not you go back to some other faster way of getting a solution? They are looking at SARFAESI now more, wherever they have the asset. Am I right, sir?
Yeah, that is true. Now, I mean, people are now going back to the previous avatars of IBC in pieces, and they find that they are in a way better there rather than taking more time here. At least first they get across with the, I mean, occupy the property, take over the things, and if possible, even put it under sale. Whether they are able to immediately realize the money or not, at least they take over the assets.
Absolutely, sir. Absolutely. Good, sir. Good. Thank you. And CS as KMP of a company, which is let's say, a solvent company, but then they find the going tough, and the management would like to say that, let me not continue risking the position here. I would like to settle everybody and then go calmly, peacefully, and have a peaceful death. So that's a voluntary liquidation process under Section 59. So settling everybody, including the shareholders, it is allowed under Section 59. So voluntary liquidation. So that is also a case where, if I am a company secretary there in that company, where the business cannot be carried on for long in a viable or a profitable manner, then the management has to take a call. So I can advise the company that this is the way, voluntary liquidation is the way. So you don't hurt anybody in the process. There is no haircut to anyone. And finally, you sign off, from the books of, the registrar of companies, MCA, everybody is given a closure. So you can support, you can advise as a KMP, the company and the directors and the management. So this is my third case. And the fourth case is CS as KMP under IBC process, which means that the company is having some difficulty and has been dragged into IBC, and you are there as company secretary. You happen to be there as a company secretary. Despite your presence, the company has come into IBC means something is radically wrong, and you are still continuing there means something is more wrong. But still, nevertheless, you are there for some more time. And okay, so in that case, what is the role of a company? So you need to cooperate. You need to provide, some kinds of information. You are a KMP. Suddenly you start reporting to the IRP or RP and give the kind of information, data requirements. And if the company is operating, the company is having operations continuing, you have to continue with your compliance calendar. So what are all the things you have to do? Those things you need to maintain and you need to control that. So that will be your role as a KMP under IBC process. Okay, so there are certain observations made by courts that what is the role of CS in a company as KMP, whether as an officer in default, are you responsible for certain wrongdoings of a company? Yes, there is some decisions. In one case in Chennai, Technology Frontiers India versus Global Sports Commerce Private Limited case, I think the observations of NCLT were in favor of the company secretary as the watchdog of corporate governance, and he is the person to ensure compliance, transparency, and ethical conduct. He is also expected to act with proper diligence in statutory matters and report material deviations or non-compliance to the appropriate authority. However, CS is not a bloodhound and not liable for detecting every hidden or fraudulent act unless it was within the scope of their duties or knowledge. So it's a very kind of matured analysis of who is responsible for what. So a company secretary cannot be faulted for the director's, misdoings or wrongdoings or misadventures kind of a situation. So the last case now comes CS as secretarial auditor of the corporate debtor under IBC. So I am happening to be, let's say, in the company. No, I'm not in the company. The company is under IBC. I am a secretarial auditor for the company, which means that the operations or the share capital or the borrowings is up above the threshold level. It's a sizable kind of a operations of the company, and I am the secretarial auditor of the company. So what I should do in this kind of situation? Recently, I've come across a company where it's a listed entity under IBC, and the secretarial auditor was appointed for 5 years. So situations happen like that because it's a compliance requirement. So secretarial auditors from 1st of April 2025, their appointment is for 5 years. So 5 years appointment happens. So you continue to be the secretarial auditor as long as the company is surviving, as long as it is alive. So that role during that kind of a time, there are certain additional watch lists. You have to be more meticulous, careful on what's happening on the IBC front. So what is your role? So you have to be extra vigilant in that kind of situations. So this is the kind of a rounding up. I also wanted to highlight to the participants the importance of CS under IBC process. The case of Jet Airways, where Mr. Ashish Chacharia was the IP. He is also a company secretary, a fellow company secretary. Most of our members will be definitely aware of what happened to Jet Airways, what kind of headwind Jet Airways faced. There has to be certain reasons for its failure. So the rise and fall of Jet Airways definitely is worth writing a book on its journey. They try to survive. They try to face a lot of difficult situations, but then gross mismanagement, I should say, or ineffective management, financial management, and then diversion of funds. I think the promoter of Jet Airways is still in imprisonment behind the bars. So, but finally, this company had to be pushed into liquidation. Okay, so, but in the process, I think the company secretary as a team faced, cross-border situations of creditors. Aircrafts were in European countries. They did not allow the aircraft to be released. So much of things were there. And the slots, various slots belonging to Jet Airways were occupied by other airlines because you cannot keep certain things forever. So the resolution plan which got approved also could not take off because I think that is the point in time when PF decisions, PF dues to the employees became very, very, critical, and it was becoming very clear that the courts will not compromise on payment of PF dues. So the PF dues has to be provided. So in this case, the resolution plan did not provide for PF payments. And the court in CLAT ordered that apart from the resolution plan money, what you have given, you have to bear the PF dues as well. So I think that was the last straw on this camel's back. So it fell through. The resolution plan fell through. The Jalan Kalrak Consortium, they were already delaying matters. They were worried. But finally, I think every bit of the resolution plan was chipped away, and it fell. It completely collapsed thereafter. So now it is in liquidation. There again, thanks to Supreme Court giving a kind of an order that you put the last nail on this company. So key takeaway in this case was that the company secretaries had a lot of role in getting all the complex situations, presenting it, and then bringing it before the courts. Challenges they were faced at the time. Creditors were willing to take even small money with a huge haircut. They were willing to take in Jet Airways case, but then it was not going to happen. And now that company is going for liquidation, they will not get even that kind of a money as well. Okay, so this is the situation, and I am just coming closer to the end of our presentation. career opportunities and way forward for CS in IBC ecosystem. So I'm also having a big question mark as to how the IBC landscape will pan out in the next 2 to 3 years. Situation looks to be grim. Of course, the sky is overcast. It's not gloom and doom everywhere. There are still some opportunities are there. It is like, people where they find some of the pending cases where assets are there. Even though you are not an IP, if there is an opportunity of a value for that particular company's assets, then you can guide your client, you can advise your client that here is a parcel, a land parcel, you get 30-40% discount value. So that is where some kind of an opportunities are there. So CS plus LLB, I think maybe if you are a pure CS company secretary, please do look for opportunities to arm yourself with a legal qualification, the law qualification. That would be a kind of a very cutting edge kind of technology you will have in today's context, a winning combination. You can rely upon either an IP service or a kind of a litigation. I've seen people switching from IP to litigation. Mahalashmi, she's here. Mahalashmi, are you there? Okay, so if she's there, I think she will give a voice out. Key skills for the future: forensic accounting, asset valuation, negotiation skills, and technical proficiency. So this will take you through the difficult situations if you are having a kind of an ecosystem and multiple skill sets, so that one sector going down, IBC practice, IBC process as such, getting an assignment, if it is not there, what else could be your revenue generating kind of an options? Few options are, as I said, consultancy options or representation before NCLT and GLAT. So those kinds of opportunities can always be explored. And forensic audit or accounting, though it is not the prime area of a company secretary, but still I have seen firms where they have applied their mind and created finally delivered some kind of a conclusive a document, meticulously plotting all the transactions and movement of monies, which a CS can as well do. It is not that only a chartered accountant or a cost and management accountant can do. So there are very good set of professionals and people who have their own teams can do with a top direction by you as the company secretary. The team can definitely do very good job on this. Valuation already, CS valuation people, professionals are there on the financial assets, securities and financial assets. But, that scope is getting very much less these days. The financial asset is the first one to go out of the system. Am I right, Mr. Nageshwaran sir? If there is money in the company, that first goes out.
Yes, and that, yeah, even before the company gets into any major difficulty, first they will encash it.
Correct. And if there is some receivables in the company, definitely they are not receivables. They are just in the book, to be an ornament, to support the asset side of the balance sheet. The receivables are kept. So the receivables are easily beyond 3 years of duration of default. Anyway, so these are all the areas, and I'm coming to a sort of a conclusion that the CS professionals are definitely a kind of an integral part to the IBC process, thanks to their exposure on various aspects of corporate functioning and governance requirements and stakeholders coordination. But nevertheless, I'm not attempting to say that the other professions are Mr. Nageshwaran is an ex-banker. We have Mr. Nandakumaran, he's also an ex-banker. And some of the professionals, IPs here, I'm sure there will be somebody who has been in the banking sector. Anyone, sir, in the banking sector? Definitely people would have been there. Some trust with employment in a bank. So they will definitely appreciate that, they will have a better kind of an appreciation. This would have happened, that would have happened. Most of the times, MSME sector people, when they taste some money, when they taste some profit, and they take some additional loan and they put it in another asset. And sometimes I think maybe Mr. Nandakumaran would help me. He's a company secretary and retired DGM company secretary from IOB. The bankers themselves go and offer loans to people because they have some targets, they have some pressure of performance. And if there is an average kind of a borrower who has been so far regular, hello, come here, why don't you take this asset? It's a good asset, I will fund you. So they fund them and they make him to take over that asset. Eventually, that asset pulls him down after some time. So this is what it is happening. And people say that, the haircut in the IBC process, even though in the initial days it was not that prominent, excepting that Synergy Dure case. Synergy Dure, the first case, I think it had about 95% haircut, if I remember, sir.
Yeah.
Other participants may correct me. Synergy Dure with Ms. Mamta Banerjee as the RP was the first case under IBC to be appreciated, but it later on got into some kind of litigations as well. But the haircut was, quite high in that case. And that being the situation, IBC had its own ups and downs. The recovery rate fell through after some time. And now it is a case of personal guarantees, PG to CDs. So PG to CD is one situation where more number of cases are now coming up. And it had hit a roadblock thanks to the litigations before Supreme Court. And while Chief Justice Chandrachud, before leaving the office, cleared that kind of constitutional validity questions were answered, and thereafter now this process has taken off, and we have been recently successful in one PG to CD to conclude the matter and get a repayment plan approved and get the money and distribute the money recently. Of course, the recovery or this thing cannot be compared because we are talking about the CD's outstanding dues in the personal guarantor case. So it is always, hovering in a single digit recovery for the bank. When I say single digit, it can even be as low as 1%. So that is the situation now. But I think in the next few years, more number of PG to CD is likely to come up, I think. Am I right, Mr. Nageshwaran? PG to CD cases may come up more in number.
It should be coming up more in number, provided the financial institutions are in a position to keep their documentation
properly
and do not get into a problem of limitation getting hit.
Absolutely correct.
So here one interesting input.
Yeah.
I've been told out of PG to CD cases, hardly around 35 cases there was a resolution plan. Remaining cases were not resolved. One. Second, NCLTs are not ready to declare bankruptcy.
Okay.
This is a difficulty all people are facing, RPs and IRPs are facing.
Oh, I see. Any reason, sir, why they don't?
There was so far no case where the direct PGs were declared as bankrupt, and NCLTs are worrying about not being a first of its case.
I see. On the other hand, it could be an opportunity for them to be
that, but no. There are 6 months in one of my friend's case. He filed for bankruptcy declaration. It should be automatic kind of scenario. The law
Correct.
permits after 1 year and a kind of they should be declared. It
Okay.
is 6 months after filing. Even then, the NCLTs are not pronounced.
Okay. Okay. But then, sir, the PG to CD cases, as I was, about to say that even though we had completed one repayment, it contains a lot of gray areas. What is the role of RP? Is he going to
Monitor.
play the role of a detective to find out all the assets of the personal guarantor or his immediate family?
Yes, sir.
These are all some big question marks in the system as of now.
Yes, sir.
And hopefully, I think in the coming days, some more cases happening and people going to the court, they will get some kind of a judgment. What is the role? Let's hope that that kind of a situation comes.
Yes, sir.
Okay, sir. Okay. So I would like to conclude that the roles of CS, even though we have faced so far, but it continues to be evolving and taking up more of orientation on the legal side, because the legal profession, admittedly, the longest profession, you call it as a noble profession along with the medical thing, but legal profession has its own plus and minus. We see after this IBC coming into existence, the legal professionals' demand and then the kind of fee structure has tremendously shot up. I can say that. Am I right, Ilamati? Is there any other legal professional in the group?
I'm sure there must be some participants who are in legal background.
At least one person from a legal background. Can you please share your? We have Mr. Niranjan here. Niranjan, is he available?
Sir, yes, sir, I'm there, sir.
Yeah, yes, Niranjan. You've been, Mr. Niranjan is an insolvency professional going to become PGIP graduate from the IACA course, and he's also a LLM. Yes, Niranjan, you want to say something about the legal profession? Is it making merry now after IBC?
Sir, yes, sir, definitely. Sir, legal profession has an edge and it is very good, sir. Even in my course, when I was there, out of 50 students, mostly 48 students were from legal background, and those were advocates who completed this insolvency course. And this is happening for past 5 to 6 batches, and even the present batch, when there are 50 students, 97% are from legal background who do PGIP course and who wanted to become an IP. That is the situation.
Very good.
Yes, sir. Yes.
But at the same time, I think one has to be like, a thoroughly professional approach, because not all the people get that kind of an advantage. A select few gets.
Yes, sir. Definitely.
People, known faces, and so those kind of a thing. But by and large, I think a number of cases also have gone up after the IBC coming into the system. Otherwise, the NCLT is now, I can say, almost about 80% of the cases are IBC. Am I right?
Yes,
sir. Yes, sir.
Only 20% odd comes to company matters like company law, Companies Act related matters.
Yes, sir. Yes, sir.
Absolutely. Okay. So the haircut to the bankers means, somewhere the money goes, not exactly the same from the same money, but some of the professions, including insolvency professionals and the legal professionals, supporting professionals, they get some kind of revenue. That's good in a way. But I must say that the bankers getting haircut, insolvency professionals also getting haircut. I remember now I'm now 7th year in the IBC or 8th year in the IBC. I've lost almost 70-80% of my hair. So that haircut also counts in the process. So let me come to the final kind of a thing. Do we have questions and do we have any other perspectives to share on this topic, being a company secretary, and what are their roles? Most welcome. It would be a pleasure to interact with the learned professional colleagues present here. How many of them are here right now? Almost 38 people are there, right?
Yes, sir.
Okay, 38 participants are there. Good, very good. So may I ask, in particular, any person or anybody would like to say something? Pratibha Kandalwal, ma'am, are you there? Ms. Pratibha Kandalwal. Ms. Ramela Rangasamy, ma'am, would you like to share something?
Sir, good afternoon, sir.
Good
Sir,
afternoon, good afternoon.
can I ask one clarification relating to claim, sir? Sorry to ask the query.
Absolutely, ma'am. Most welcome.
Yeah,
Please
sir.
do.
In a case of a claim from a financial creditor, they are not providing the interest computation, sir. If you ask, no, they are simply giving a sheet, and they are not showing how they have computed the interest part. If you ask, they are saying that it is the generated by system. This only we can provide, like that. They are answering. Can we accept that based on the banker's book evidence they are giving, no declaration?
Okay, okay.
Yeah.
Okay.
So in that, if based on this, how can we accept their claim?
Good question, ma'am.
Mm.
The situation like this has happened in some of our claims also, where the transactions are related to many years, and they dump the numbers, in an Excel sheet or in an Excel file. This is the interest. This is what the system has calculated. If it is possible for us, to get the interest rates, we should be in a position to work out. If they are not providing the interest rate or the method how they have calculated, then you are free to have your own computation. And if it is at variance, if it is less than the amount claimed by them, then you should reduce their claim. You should admit it to the reduced portion. See, they can say it is a Banker's Book of Evidence Act, which can be relied upon by the insolvency professional. Many of the cases I see in IBC, financial creditors claim to the last paisa it is admitted. Exactly claimed, exactly admitted. But I remember in most of our cases, we have gone through the papers, we have gone through the calculations, and we have reduced it. And some bankers even felt uncomfortable. Why are you reducing my claim amount? But then we have an explanation. This is the interest rate. This is the workings. This is the number of days. This is how we are calculating it. So if possible for you to get a hold on the interest rate, there has to be an interest rate, right? Financial debt.
Yes.
There has to be a document. If there is no clarity on the interest rate, then we can even say that it is ambiguous, number one. If it is not having a time value of money interest portion, then it is even not a financial debt also. That kind of a stand also we can take. So in my view, ma'am, that you can attempt to recalculate, revise the workings based on that. If they are not able to provide you the complete workings, we can compute it. We can arrive at the interest amount. And if it is lower than their claim, we can definitely reduce the claim. If it is more than the claim, we need not increase it. We can just go ahead and then accept it. Raghu, I think, am I saying the right thing, Raghu? Because we have seen this case in recent, a few cases where the claim amounts, it was a huge amount, and we found some kind of mistakes also. It is because of the system itself is doing it, doesn't mean that it is error-free.
So for the purpose of Evidence Act, the bank statement can be taken for evidence.
Okay.
But in the IBC process, the calculation must be clearly provided by the banker. It is not that it is not that whatever stated in the bank statement should be taken.
Correct.
No court will state that. See, it can be taken as a record, but you cannot rely upon the workings on that. we can very well ask the explanation for them.
Correct, sir, correct. We have bankers also here. So Nageshwaran,
apart from this, no, the hypothecation agreement which they execute, no, it speaks about the interest rate from time to time as per the RBI guidelines. Like that, it is mentioned. What the general clause is there. From time to time, they are increasing the rate of interest. They need to intimate it to the client, no? To intimate to the CD, correct?
Correct.
Simply based on this deed of hypothecation, they cannot take a liberty to say that they have increased the rate of interest, correct?
I think there is a question of difference might arise. For example, I am the borrower, and if I make the statement that without informing me, without taking my consent, you cannot increase the interest rate, I don't think any bank will accept that kind of a stand, because they will say that whenever there is an increase in the interest rate linked with RBA or something, I will have to increase it. I will increase it. I will keep you informed. But not keeping you informed will not prevent him from increasing the interest rate. Maybe I'll check with Mr. Nageshwaran, sir.
100%. See, that is the statement itself, and that is originally when the document is executed, they will connect it with the interest rate of RBI or anything else. Whatever the benchmark they want to provide, that benchmark will be provided, and with that plus or minus will be the how it will be arrived at, they would have stated. One thing indicatively in all these matters need to be taken on that is internally the banks, it is not just simply because of the benchmark rate going up and down is not the thing. Benchmark rate will be going up and down based on that, how this particular case interest rate has been changed. They definitely in everywhere, even in the mechanized system, it would have been recorded there in the interest rate in the profile of the account. There will be in the profile there will be a place called interest rate applications. In that they would definitely will have to record it from which date to which date what interest rate has been applied. It is in the profile of the account.
Yeah, correct, sir. Absolutely.
It has to be there, and that need to be downloaded and given by the bankers. That from the profile they will have to say from what date to what date what interest rate has been applied, and all these interest rates, not just because of the benchmark rate, there will be an internal circular by every bank internally. Based on that only it is applied, not just because RBI changed the next day onwards, no bank is changing the rate. The bank will have to have internal circulars also, how they are tweaking in the change in the interest rate. So based on that, they will have to have the thing, and any bank which is not saying that they are not having that interest rate and interest is automatically applied by the system, it is something which is questionable.
Correct, sir. Absolutely.
Sir, good afternoon.
Yes, sir.
Sir, to WhatsApp what that Nageshwaran sir told now.
Yeah.
Sir, there is a working sheet attached with every loan accounts.
Okay.
If he insists the banker to provide that working interest working sheet, they have to give separately.
Yes,
we
sir.
can cross-check whatever that interest applied in the loan account.
Okay.
It is as per the interest working sheet only.
Okay.
It is a back-end system will automatically develop, sir. If anybody is asking that a sheet to be provided, they have to provide.
Oh, okay.
Exactly.
We can verify it, sir.
Yeah, sure. Mr. Nandakumaran, by the way, he is the company secretary, and he was the retired DGM and company secretary of IOB, part of our team. Thank you, Nandakumaran, sir. Amidst your pressing commitments, you have been able to join us and share your comments and views. Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you.
Is there any other point, any other question from our team members? I have one point I thought before we sum up this session and say goodbye late in the Saturday afternoon. IBC, why there is a slowdown, and is it because of exclusively the delay happening in the judicial process, the completion process, or suddenly the borrowers are all becoming very prompt and there is no default happening in the system. Is it because of that? Or is there any other factor? Judicial delays, credit discipline improving, or X factor, any other factor? Number of cases, I would definitely say that, the new cases admitted or any new assignments coming, a slowdown. Am I right? The participants will agree with me. There is a complete slowdown. So is it because the bankers are saying that, it's becoming an expensive affair? It's a luxury for recovery. We spend more than what we recover. I request the participants' views, the seniors and all, even youngsters, legal professionals. Maybe 2 or 3 of you would like to share some of your views, please.
So I think I'll myself, Ramakrishna, will add my
Yes, sir. Please,
observations
sir.
on this. If you see the recent judicial interventions with respect to approved resolutions plan like Bhushan Steel and all,
Yes, sir.
IBC undergoing a tremendous stress. No
Yes,
guarantee, no guarantee for the SRA that even after the resolution plan achieved and approved,
yes,
and
sir.
then he'll be peacefully allowed to continue.
Correct.
Continue. One. Second, sir, even the as we sometime back during our talk itself, we were talking about clean slate. There is no clean slate, sir, in IBC.
Yeah.
There no even courts are worrying. They are not taking aggressively and trying to see that IBC, the spirit of IBC is upheld. And concessions and reliefs as becoming a mere instrument under 32 years. So these kind of uncertainties, SRS are not coming forward. Second, banks are becoming vexed with the process, especially with the timelines which tribunals is taking. Third, though IBC code has timelines for every stage, but now I think that is becoming mere bullshit.
Merely on paper.
Timelines are becoming big jokes, sir.
Yeah.
See, if originally, if you recall, when the IBC was introduced and the then chairman of BLRC committee, he said, no, IBC is an automatic process. If there is a debt and default, the case should be automatically admitted.
Correct.
Of course, later courts have intervened and they used the Companies Act provision for introducing the notice to other party kind of, the provision is there, RD alterum partem, which NCLT has to observe, and that's all fine. But NCLT is for admitting the cases, whether PG2 CD case or other cases, they're taking their own sweet time in resolving the issue. One. And I have my own case where, sir, it is a case of Section 10. Section 10 case. Imagine I have to file Section 19 application for non-cooperation.
Oh.
And it took 1 year, 2 months to dispose Section 19 case.
Oh.
This is this kind of pace with which the pillars of the IBC were crucial is functioning and cooperating, supporting for an IBC. IBC will definitely undergo stress. And I think I recall recently this MS Sahu, our former first chairman of IBB, also written saying that IBC under stress, referring to Bhushan Steel case and referring to Vidarbha cases, referring to Rainbow cases, referring to the electricity department cases. Nowadays, all cities are facing problem of electricity connection.
Correct.
They are not giving connection.
Correct.
You go wherever you go and tell. And NCLTs are not disposing.
Yes.
I think IBC is coming with not so much wounds, sir. It's not a real clear case.
Absolutely correct. That is a very nice summing up, Mr. Ramchandra Gupta.
Thank you, sir.
Really a very apt kind of summing up.
Thank you.
Is there any other participant wanting to say something, sir?
In fact, I want to add to Mr. Ramakrishna's
Mr.
version. Sir, even if he filed 19.2, nowadays benches are giving that he will cooperate. An order stating that the promoter will cooperate, and just like that they dispose of the order.
Yes.
And again, we are going back to the square one and fighting with the promoters.
Correct. They don't want to.
We are not We are not getting any solution out of it, and it has become merely a process and a record. That's all.
Absolutely. And added to this, I think the kind of cases sometimes which are still unresolved in IBC, and they are taking more number of years. If you see, some of them are the real estate cases. The promoters of the real estate company, they have already scooted, taking the monies, and the poor home buyers are left in the lurch. And sometimes when there is a joint development agreement, recently our team was highlighting to me an order by Mumbai bench, joint development agreements, to what extent they have sanctity or relevance. There are so many cases where the home buyers have been left in the lurch. So it's very pathetic, sir. IBC, I have not expressed a few terms like IBC is being gamed by some people. Definitely they are doing it. And they manage it in such a way that they enjoy the protection of moratorium, and they also enjoy running the company as they like and keeping the matters before NCLT or NCLAT as much as possible, as much as they wish, put in the back burner or keep it in the last of the bundle, or if they can even say the bundle has disappeared. Or in a very nice way, it will get listed in 30s or 40s of the item list. So the bench does not have time beyond 10 cases or 15 cases. So you easily jump from August to January and January to July. So the jump is very smooth and fast. So this is how it is going. And as Mr. Ramachandra Gupta said, it looks like IBC is under IBC now.
In stress, yeah. IBC in stress.
Yeah, absolutely.
More so, sir, appellate tribunals. Appellate tribunals in our matter never comes.
Yes.
That is
exactly, sir. Exactly. That is what I was telling. So it gets listed in 30s, 40s. So when it will come? It will never come.
Never come. Yeah.
And sir, my view, one point I want to add here is that I now of late I feel that even IBBI has also accepted this reality that this will go on like this, because in some of the cases I had taken up the matter with the IBBI and they are also non-responsive in some cases. I took up some cases of filing or initiating the prosecution, and those mails remain unreplied. Maybe if they don't want to take, they should reply to me that, look, this is not possible, or you have to do like this or something like that. But there is no response. And when we followed up with them, they said, no, you first go to NCLT. If they direct, then we will do something. Then I told them there is no such requirement that you need NCLT approval. But there is no response. There is no clarity. Whereas the director, if somebody files, I have come across a case where the directors filed a complaint under the complaint and grievance regulation. It has to be dealt. Correct, sir? But the notice to IP has been issued under the inspection and investigation rules.
Yes, sir. Absolutely. Absolutely.
So isn't it so that the complaints against IPs, they are rushing to investigate and inspection? Rather, it should have been dealt under the grievance and complaint regulation. But whereas when the IP is initiating request for prosecution, if he or she comes across any kind of need for prosecution, in my case, there have been no handing over of the accounts, fabrication of accounts. I have raised, although before NCLT I am raising, but there are certain issues which I have raised before the IBBI also, but there is no response.
Yes, sir.
So obviously, maybe because of all these things, bankers are also getting fed up.
Yes, sir. Correct. Absolutely correct. Bankers are almost like they have come to a conclusion that IBC is a very costly kind of a means of recovery, and it's not worth the time and efforts. So probably they are taking a U-turn and then they go look elsewhere.
And as it is, bankers also they also take a lot of time, because IBBI has made a regulation that whosoever comes to represent the FCs or COC member, they should have adequate powers to take this the decision on the spot. But practically, you will find that every COC member will insist, okay, you put this on the voting agenda, then we'll see. Then they keep on preparing their internal notes, which takes 15 days, 20 days, maybe some cases 1 month.
1 month.
And they sometimes some are even withdrawing not to vote.
Oh.
For internal reasons.
And
I have come across many cases.
And the IBBA regulations say that after a week of voting time, you have to go on a every day, extend it on every day basis.
So sir, my view, I think, is that IBBI should take proactive role in getting all these issues highlighted appropriately. Otherwise, this profession will die. This is my feeling.
Yes, absolutely.
As it is, IPs are under a lot of stress because everybody is after IPs.
Correct.
And if there is a small mistake, IP is held responsible. That is correct. We as a professional feel that we are responsible, but other stakeholders also have equal responsibility.
100%,
so I think we as a professionals, I think we should think whether we should approach the IBBI or sensitize IBBI for taking appropriate action in this matter or not.
Absolutely correct, sir. And I think this is being voiced out in various forums. I have also been in touch with 1 or 2 senior persons. But then, sir, this matter of number one, response to your request, or the larger issue of Supreme Court decisions and how the NCLTs interpret further matters, I think it is a very serious cause for concern. And I think before we say goodbye, I would like to ask Ilamati, the legal person here and also a company secretary. We spoke about the clean slate being not very clean, but
Yes,
32A section under IBC is a well thought out provision which says that the person who is taking over the company's tainted assets has to be a non-related person. 29A is there.
Correct, sir.
And thereafter, any prosecution can continue against the existing promoters or the erstwhile promoters. That has to continue. In that case, what prevents the assets being handed over to the resolution applicant and start being used? Why these attachments are having a kind of a strangulating hold on the assets, and the assets are losing its value in many cases. Your take,
Right.
Lamati?
Sure, sir. So firstly, I have this one observation on section 32A, wherein the provision doesn't anywhere state that an application will have to be made out to NCLT, or any reliefs, concession or request will have to be made to NCLT to get the protection under 32A. So
Correct.
essentially, the intention of bringing in 32A is to give a blanket protection to
Correct.
anybody taking over the company, either under CRP or in liquidation. So in that case, essentially the NCLTs or NCLAT shouldn't be concerned about having a second thought in this regard.
Correct.
Because when the law says that a new person who's coming in and taking the company will have a protection, and where comes the necessity of any judicial intervention to stop it? That's my first thought. But going further, seeing the recent judgments, there has been a concern around whether if such a relief is made with regard to an attachment or under PMLA Act or Benami Act, in such a case, will the law under PMLA or Benami Act prevail over the insolvency code? Because we have 238, which does say that in case of any inconsistency, then IBC will prevail. So again, here comes one more role of interpretation, whether there is any inconsistency between the law which provides for attachment and IBC. Incidentally, yesterday, Nageshwaran sir and I had a detailed discussion on a very recent judgment of Supreme Court on 15th of May National Spot Exchange versus Union of India. So this in this judgment, the Supreme Court has held that the secured creditors will not be having a priority on any asset which is attached under MPID Act, so or PMLA. So here the court is trying to clarify that even if the loan is given prior to any attachment, even if the assets are not an outcome of proceeds of crime, a secured creditor has been put down in the list now. They have prioritized the authorities who are attaching the asset. So this is definitely a matter of concern, because already by the Bhushan order dated 2nd of May, there has been a speculation whether IBC is going to, make it a viable solution to take over a company or take over an asset. This judgment is one added concern on two aspects. One, on the angle of a creditor, because they would have lent crores of money on a company.
Correct.
Where there would be no doubt on any proceeds of crime. But
Correct.
Eventually, due to some deviations or diversion of fund, there comes a proceeds of crime which fall in the asset, and for no reason now the bank is put down, they are let down on their security interest. So I think now that the Bhushan judgment is also on review, they filed a review petition recently, and the CJ has also told they are going to form a separate bench on these matters. I think the Bhushan judgment should essentially be turned down, in my personal opinion, because it will not give any value to a successful bidder. Any prospective bidder is already under concern whether they can trust NCLT, whether they can trust IBC on putting so much of money in taking over an asset. So this matter of concern is not just, as in the Supreme Court has not just decided on the Bhushan matter, but they've set a precedent on all future matters in IBC. So this concern will definitely have to be addressed on a right way by the Supreme Court.
Absolutely.
And again, this National Spot Exchange is still holding good because that's an order subsequent to the Bhushan order. So the attachment by various authorities under different acts, be it PMLA, MPID Act or Benami, I think IBC somewhere will have to be brought in light to prioritize the company suffering, so that the creditors and other stakeholders in this process are given some benefit, because coming under IBC shouldn't wash away everything. That is also a concern for the government side. So I think a harmonious construction should be the only solution in matters regarding attachment and IBC.
Absolutely. Do you think that, without taking into all these factors under consideration, the Section 32A would have been inserted into IBC? Definitely, those factors were there in their mind.
Yes, sir.
Isn't it?
It must have been there.
And I believe very strongly that 32A was insisted by ArcelorMittals. And they said that I'm going to pump in 40,000 crores of taking over SR Steel. Tomorrow you will say, this attachment will prevail, ED will take away my asset. Why should I put this money? So 32A came, and thereafter only this whole process got approved. The resolution plan and the money came. The legislators rushed to bring this by way of an ordinance, and then later on it got regularized as an act, I think.
Right.
So very unfortunately, this Bhushan Steel order is having a domino effect in so many other judgments being rolled out. The people are very happy. They are trigger happy to refer to that judgment and say that, the apex court has already decided like this. So somewhere I think people call that, suddenly an act, legislation, IBC. IBC says that I am supreme to everybody and I can do anything I want. I have overruling powers. I think this has not gone down well with the judiciary, I think. The judiciary is used to see things in a normal, logical perspective. Suddenly, IBC is coming and saying that you did not file the claim, you go away. You are an operational creditor, go away. You don't have any voice. You are an unsecured creditor, nothing for you. You are an employee, be at home, nothing for you. So I think this is now acting in a mentally kind of overhanging in their mind is coming out as voices of the judiciary to set things right according to them, perhaps. So let me not add to this anymore, because it's a matter of, so many courts are there and so many aggrieved parties are there. Let's hope that good things will prevail, good sense will prevail, and we will have the company secretary profession will continue to flourish. IBC is there or not. Not all the company secretaries are into IBC. Am I right? So some people. So let's hope some kind of a positive developments. So with that note, I would like to conclude the session. Anjali, are you there?
Yes, sir.
Yes. So we have ended the session, Anjali, and with questions and answers. And thank you very much for this opportunity.
Shall we conclude now, sir?
Sorry.
Sir, shall we conclude now?
Yes, please.
Then you are requested to please share the footage of the session.
Okay. I'm